everybody. Well, this is the document that was filed yesterday with the State of Wisconsin Circuit Court, Manitowoc County, in front of Judge Angela Sikowitz. It's going to be the judge presiding on this motion, just like all the prior motions. But here we go. State of Wisconsin respondent versus Stephen Avery petitioner. Notice for motion and third motion for post-conviction relief pursuant to Wisconsin statute 97406 and 80515. Table of contents, table of authorities, introduction, statement of case, procedural history, third party suspects, verdict, post conviction and direct appeal, the appellate court's July 28th, 2021 decision, petition for review. The appellate court reserved Mr. Avery's ability to file a successive 97406 motion on certain claims. Evidence supporting Mr. Avery's third 97406 post-conviction motion. Newly discovered evidence. New witness provides direct connection between Bobby and the Halbach murder. Sawinski's report was discovered after Mr. Avery's conviction. Mr. Avery was not negligent in seeking the evidence. The evidence is material in the issue in Mr. Avery's case. Pellicle law, read Denny. The Denny requirements are now satisfied. A. Bobby motive to commit the murder of Teresa Halbach. B. Bobby's opportunity to commit the murder of Teresa Halbach. And C. Bobby's access to items to evidence to frame Mr. Avery. Bobby had access to Mr. Avery's blood. Bobby's direct link to the murder of Ms. Halbach. The evidence is non-cumulative. Reasonable doubt as to Mr. Avery's guilt. Brady violation. Read the Sawinski evidence. Federal law, read Brady. Mr. Avery is not procedurally barred from raising Brady claims. Second Brady violation, read Halbach RAV4. Mr. Avery is not procedurally barred from raising Brady claim. An alternative, Mr. Avery is entitled to new trial in the interest of justice pursuant to 80515. An evidentiary hearing is required. Conclusion. Alright, here we go. Bunch of case jibber jabber. Okay. Notice of motion, third motion for post conviction relief pursuant to Wisconsin statute 97406 and 80515. Please take notice that the petitioner, Stephen A. Avery, Mr. Avery, by and through his current post conviction attorneys, Kathleen T. Zellner and Associates, PC, respectfully moves his court pursuant to Wisconsin statute 97406 for an order vacating the judgment of his convictions and sentence and ordering a new trial. An alternative, he asks the court grant a new trial in the interest of justice pursuant to 80515 of the hearing authority because the real controversy was not fully tried. In support of his motion, Mr. Avery states as follows. Mr. Avery requests evidentiary hearing that he's produced for the hearing. Introduction. The two new witnesses have emerged in Mr. Avery's case with new and compelling evidence about a murder mystery that has intrigued a worldwide audience. The rush to judgment and tunnel vision that led to the arrest, prosecution, and conviction of Mr. Avery is exposed by the new witnesses who provide new, undisputed evidence that directly links Bobby Dassey, Bobby, to the murder of Teresa Halbach and the framing of Mr. Avery. Furthermore, this new evidence allows for reconsideration of the real motive of the crime, as being a sexual homicide which was cumulative in a possession by Bobby with the viewings of thousands of images of violent, deviant pornography on October 31st, 2005. The obsessive fantasies of Bobby become horrible reality with Teresa Halbach was brutally assaulted and murdered by 2 rifle shots to her skull. Her body was mutilated, as were many of the female subjects in the Dassey computer images. Bobby was in possession of a Halbach vehicle, which contained the crucial evidence of the terrible crime. Miss Halbach's blood, key, electronic devices, license plate, which was concealed in another salvage car, and Mr. Avery's carefully deposited blood on the seat and dash, and DNA on the hood latch. By being in possession of the vehicle, Bobby was able to control the direction of the investigation. He planted the vehicle on the Avery property after he deposited Mr. Avery's blood and DNA in it. He had Miss Halbach's key and electronic devices, which ended up in Mr. Avery's bedroom and burn barrel. Bobby did all this to exploit himself to frame his uncle. Mr. Avery does not have to prove who committed the terrible crime to receive relief. This is not the intent or purpose, however. He does have the right to prove he did not receive a fair trial. The new evidence which establishes that Bobby meets all the Denny criteria and the third party suspect, and the evidence of the two Brady violations demonstrate that Mr. Avery was deprived of constitutionally guaranteed right to present a complete defense of the charges against him. Statement of the case. This case began in early November 2005 with the disappearance of Teresa Halbach, a 25-year-old professional photographer. Ms. Halbach was reported missing on November 3, 2006. Volunteer searchers found Ms. Halbach's Toyota RAV4 on a 40-acre site in Avery Auto Salvage, a salvage yard business where Mr. Avery and other family members lived and worked on November 5, 2005. Ms. Halbach was photographed vehicles at the site previously, per Mr. Avery's request. According to state witnesses, Bobby, Ms. Halbach, was last seen walking towards Ms. Avery's trailer on October 31, 2005. After finding Ms. Halbach's RAV4, law enforcement searched the Avery property and over the course of the next 4 months discovered and identified evidence including burn bone fragments in and around a burn pit with the DNA matching Ms. Halbach's, Mr. Avery's, and Ms. Halbach's blood in the RAV4. The remnants of electronic devices and a camera, the same models as Ms. Halbach's, and a burn barrel. Ms. Halbach's RAV4 key in Mr. Avery's bedroom with Mr. Avery's DNA on it. Mr. Avery's DNA on the hood latch of the RAV4 deposited, the state later claimed by Mr. Avery's sweaty hands, and the bullet in Mr. Avery's garage containing Ms. Halbach's DNA. Procedural history. Third-party suspects. On July 10, 2006, before the Mr. Avery trial, the trial court entered an order entitled Order Regarding the State's Motion Prohibiting Evidence of Third-Party Liability, Denny Motion. The order specified that the defendant intended to suggest that the third party other than Brendan Dassey is responsible for any other crimes charged. The defendant must notify the court and the state of such intention at least 30 days prior to the date of the trial. The trial court further ordered that the defendant would be subject to standards relating to the admissibility of the third-party liability evidence pursuant to State versus Denny. In the light of the court's order on January 10, 2007, Mr. Avery filed the defendant's statement on the third-party responsibility. There, Mr. Avery stated that he did not kill Ms. Halbach and that there was at least reasonable possibility that one or more unknown others present at or near the Avery Salvage Yard in the afternoon, October 31, 2005, killed her. Mr. Avery identified several persons as potential alternative perpetrators: Scott Tadich, Andres Martinez, Robert Fabian, Charles and Earl Avery, and the Dassey brothers. Mr. Avery argued that the Denny did not apply to circumstances in his case, and that the results he should not be bound by third party set forth in Denny. He further argued that if Denny did apply to his case, he should be permitted to introduce evidence at his trial of several alternative perpetrators in the case. On January 30, 2007, the trial court entered a decision order admissibility of third-party liability evidence. The court held that Denny's legitimate tendency testifies in evidence the defendant wished to present regarding potential third parties who might have been responsible for Ms. Halbach's murder. The trial court found that the absence of motive certainly may have to be more difficult for the defendant to offer evidence which is relevant material connecting the third party to the crime. The court simply finds nothing in order offer made by the defendant that goes beyond the level of speculation. Verdict: on March 18, 2007, Mr. Avery was convicted following a trial of first-degree intentional homicide contrary to Wisconsin's 9401 and felony in possession of a firearm contrary to statute 94129. The jury found Mr. Avery not guilty of mutilation of a corpse. Post-conviction direct appeal on June 29, 2009. Prior post-conviction counsel filed a motion for post-conviction relief on Mr. Avery's behalf, pursuant to 80930, seeking a new trial on grounds that the trial court improperly excused deliberating juror and the trial court improperly excluded evidence of third-party liability. On January 25, 2010, the motion for post-conviction relief was denied by Honorable Patrick L. Willis in written order regarding the issue of Bobby's third-party liability. Judge Willis found the only evidence offered by the defendant to show motive and the part of Bobby Dassey consisted of evidence allegedly supporting a motive to frame Stephen Avery. No evidence is offered to suggest that Bobby Dassey had motive to murder Teresa Halbach. Judge Willis concluded the evidence offered against Bobby Dassey probably did meet the opportunity and direct connection to the crime requirements and the legitimate tendency test because the presence of property and the time Ms. Halbach was there. However, without any showing motive, third-party evidence against Bobby Dassey was precluded under Denny 453. On December 14, 2011, Wisconsin Supreme Court denied Mr. Avery's petition review pursuant to 80810. On February 14, 2013, Mr. Avery filed his first and only pro se collateral post-conviction motion pursuant to Wisconsin Section 97406. The motion was denied by Honorable Judge Angela Sukowitz, aka Judge Flowers, on November 23, 2015. On October 11, 2019, current post-conviction counsel appealed the Circuit Court's denial of Mr. Avery's second post-conviction motion of all supplements. He filed motions to stay and remand concerning two additional claims. The appellate court's direction, Mr. Avery raised the claims in the motions. The Circuit Court of supplemental post-conviction motions. The Circuit Court denied the motions supplement on April 12, 2021. Mr. Avery filed a motion to stay and remand. The appellate court denied it. The appellate court, July 28, 2021 decision. On July 28, 2021, the appellate court issued a per curiam opinion upholding the Circuit Court's summary denial of Mr. Avery's claims raised in 97406 post-conviction motion. The supplemental motions holding Avery 97406 motions are insufficient on their face to entitle him a hearing. Petition for review. On November 17, 2021, Wisconsin Supreme Court denied Mr. Avery's petition for review. The appellate court revised Mr. Avery's ability to file a successive 97406 on certain claims. On April 12, 2021, during the pendency of Mr. Avery's appeal, Mr. Avery filed a motion for appellate court to stay his appeal and remand the evaluation of the new claim. The appellate court acknowledged this claim, stating the following. On November 9, 2020, we notified the parties that their case had been submitted in the court decision and briefs. On April 12, 2021, Avery filed another motion with this court to stay the appeal and remand the evaluation of the new claim. The claim concerns an alleged Brady violation, factual basis for Mr. Avery obtained on April 11, 2021, specifically a claim based on an affidavit of Thomas Sawinski, a Manitowoc County route driver who states that days after Mr. Halbach's death, while on the paper route in the early morning hours, spotted a shirtless Bobby Dassey, an unidentified older man, pushing Miss Halbach's vehicle down Avery Road towards the junkyard. Mr. Sawinski further attested that after he delivered the paper, Bobby Dassey attempted to block his exit, causing him to swerve into a swallow ditch. Mr. Sawinski claimed to have called the Manitowoc Sheriff's Office later that day to report what he had seen, but was only told they already know who did it. He also claims he had attempted to contact Mr. Avery's trial attorneys after season 1 of Making a Murder, but never heard back to them. When Avery filed his motion, he was already twice stayed his appeal, each time because he asserted that new claims related to this previously litigated that would be most expeditious to resolve the part of the instant appeal. By the time Avery filed his new motion, however, he had already evaluated the legal and factual basis for claims already raised. Therefore, we are in a position to conclude that the newly raised Brady claim bears little to no relation to those claims already before us. This is instead a distinct issue that the Circuit Court should resolve on a standalone basis through a new Wisconsin 97406 motion. Avery's latest motion arrived for the decision appeal forthcoming. It would be an effective use of the court resources to now, and once again, delay the appeal's resolution. We appreciate that Avery likely wishes to consider the new Brady claim in context of claims previously raised, but we must weigh the implicit consideration against those discussed above. Simply put, Avery's appeal cannot continue independently. Accordingly, the decision operates in order to deny April 12, 2021 motion to stay and remand. If Avery wishes to raise a claim, he must file a new Wisconsin Statute 97406 motion with the Circuit Court. The appellate court reserved Mr. Avery's ability to file a successive 97406 motion and claim in the most recent filing concerning the new witnesses who came forth on April 11, 2021. Specifically, the appellate court instructed the following. As discussed below, We are not addressing Avery's most recent filing of the court. See our decision in motion number 6, which seeks to directly connect Dassey to a Halbach murder. If the Avery wishes to raise that claim, he will need to bring a new Wisconsin Statute 9706 motion. The motion would need to survive both scrutiny and be found to have merit, in which the evidence presented might supply the missing direct connection. In the event, the VLCD evidence might become relevant to showing Dassey's motive and might bear on whether Dassey or should have been a viable Denny suspect. We expresses no opinion or merit on any such 9706 motion, as all such issues would be circuit court decided in the first instance. Regarding certain claims, Mr. Agee raised in the motion, consider the Circuit Court's October 3rd, 2017 order denying second post-conviction motion. In his 2 supplemental appellate court found that neither were nor the Circuit Court have squarely considered whether these claims are procedurally barred from Escalon and Nerdo, and other Avery pled sufficient materials entitling him to hearing. Such consideration would have to come to separately filed Wisconsin Statute 97406 motion, and we expressed the opinion which these claims will be barred in the event such motion is filed. Evidence supporting Avery's third post-conviction motion. Newly discovered evidence, new witnesses provides direct connection between Bobby and the Halbach murder and planting evidence to frame Mr. Avery. Mr. Avery's new witness, Mr. Thomas Sawinski, contacted Mr. Avery's current post-conviction counsel in December of 2020. Mr. Avery had already filed his appeal on October 11, 2019. Mr. Sawinski stated that he had witnessed Bobby and one other individual, bearded man, pushing Miss Halbach's RAV4 onto Avery salvage yard in early morning hours of November 5, 2005. Mr. Sawinski claimed that he had reported the information to the Manitowoc Sheriff's Department. On April 11, 2021, Mr. Sawinski provided an affidavit to Mr. Avery's current post-conviction counsel stating the following. Mr. Sawinski was a motor route driver for Gannett Newspapers Incorporated and delivered papers to Avery Salvage Yard in the early morning hours on November 5, 2005. Prior to delivering newspapers at Avery Salvage Yard, he turned onto the Avery property and witnessed 2 individuals in a shirtless Bobby Dassey and an unidentified older man suspiciously pushing a dark blue RAV4 down Avery Road towards the junkyard. The RAV4 did not have its lights on. Mr. Sawinski drove past the 2 men and delivered newspapers to the Avery mailbox. And then he turned around and drove back towards the exit. When he reached the RAV4 still over there, Bobby Dassey attempted to step in front of the car to block him from leaving the property. Mr. Sawinski came within 5 feet of Bobby Dassey and his headlights and were on Bobby during the entire time. Sawinski swerved into the shallow ditch to escape Bobby and exit the property. Mr. Sawinski states in the affidavit he called the paper boy, "Gotta go," because he was afraid for his safety. He further stated that Bobby Dassey looked him in the eye and did not appear happy to see Mr. Sawinski there. After Mr. Sawinski learned that Teresa Halbach's car was found later in the day on November 5, 2005, he realized that the significance of what he observed and immediately contacted Manitowoc Sheriff's Office. Sawinski evidence provided Mr. Sawinski to Mr. Avery's current post-conviction counsel is newly discovered evidence which provides the missing direct connection between Bobby and Miss Halbach murder, making him a Denny suspect. Discovery of new evidence may constitute a sufficient reason for a second or subsequent post-conviction proceeding. To prevail, however, the movement must carry the burden of providing the evidence as an issue and newly discovered in most cases. To obtain relief based on newly discovered evidence, a convicted person must establish by clear and convincing evidence that 1. The evidence was discovered after conviction, the defendant was not negligent in seeking evidence, and 3. The evidence is material in the issue in the case, and evidence is not merely cumulative. If the person satisfies those 4 requirements, then the circuit court must determine whether a responsible probability exists that different results would have reached in a new trial. The Sawinski evidence discovered Mr. Avery's conviction. Mr. Avery did not have Sawinski's evidence before Mr. Sawinski came forward. Mr. Avery's current post-conviction counsel on April 12, 2021 Mr. Lewinsky attempted to contact Innocence Project and did not, and not Mr. Avery's child defense counsel, by email in 2016 regarding the evidence he had. To no avail, he had no previously provided Mr. Avery's counsel. Rather, Lewinsky evidence was reported to Manitowoc Sheriff's Office by Mrs. Lewinsky, but the evidence was suppressed from Mr. Avery by the prosecution. Mr. Avery was not neglecting seeking the evidence. Neither Mr. Avery nor his counsel were on the notice that Mr. Lewinsky had any knowledge about Bobby's actions on November 5th, 2005. Finding Williams did not fail the glance of pursuit of the juror misconduct claim. Record contains no evidence which have responsible attorney or notice. Blah blah blah. Evidence material issued in Mr. Avery's case. The Lewinsky evidence material for several issues in Mr. Avery's case. Most importantly, it's material for establishing Mr. Avery's defense that is third party committed the crime against Ms. Halbach, and material for establishing the direct link to Bobby as a third party identity suspect and opening the door to reconsidering the VLCD as established as a sexual motive for murder. Additionally, the Lewinsky evidence material and evidence of the RAV4 being planted by Bobby, including Mr. Avery's blood and DNA. The RAV4 also contained the Halbach vehicle key and Ms. Halbach's electronic devices, which were discovered in Mr. Avery's bedroom and burn barrel. Respectively, further, the Lewinsky's evidence is material that imaged Bobby's trial testimony that Ms. Halbach never left the Avery property and that she was last seen walking towards Mr. Avery's trailer. Bobby was the state's primary witness against Mr. Avery during the opening statement. Prosecutor Crass officially informed the jury of the significance of Bobby's putative observations on the date of Ms. Halbach's disappearance. You are going to hear that Bobby Dassey was the last citizen that will have seen Teresa Halbach alive. Bobby's testimony was the most determinative of Mr. Avery's guilt because the state used to establish Ms. Halbach never left our Avery property alive. Bobby was one of two only witnesses to testimony the jury requested reviewing during the deliberations. At trial, Bobby testified that he observed Ms. Halbach light green or teal-colored SUV pull into the driveway at 2:30 p.m. on October 31st, 2005. Bobby observed Ms. Halbach exit her vehicle, start taking pictures of his mom's maroon van right in front of his trailer. Bobby testified that he then observed Ms. Halbach walking towards the door of Mr. Avery's trailer. The following exchange occurred between Prosecutor Kratz and Bobby. After seeing this woman walking towards your Uncle Stevens, did you ever see that woman again? No. When the defendant seeks to present evidence that a third party committed the crime for which the defendant is being tried, the defendant must show a legitimate tendency that the third party committed the crime. In other words, the third party had motive, opportunity, and direct connection to the crime. To support the introduction of the third party evidence, which must be a legitimate tendency, and the third person could have committed the crime, the defendant needs to not establish guilt to the third party to the level that would be necessary to sustain conviction. However, evidence that simply affords a possibility grounded suspicion against another person should not be admissible. The legitimate tendency test asks whether the preferred evidence is remote in time, place, and circumstances. The direct connection cannot be made between the third person and the crime. The general requirements are now satisfied. Bobby, motive to commit murder of Teresa Halbach. Under the motive prong, the court must question whether the alleged third-party perpetrator had a plausible reason to commit the crime. A defendant's motive to commit a homicide is widely considered to be relevant. The admissibility of the evidence in the third-party motion committed the crime against the defendant, similar to where would the third party were the trial himself. Other acts evidence may be admitted when offered purposes such as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, absence, mistake, or accident. The law enforcement considered pornography as evidence of the motive in Ms. Halbach's murder. The clear working theory of the investigators was the murder of Ms. Halbach was motivated by sexual assault. Pursuant to the theory, the Dassey computer was seized by law enforcement on April 21st, 2006. The evidence of Bobby's motive to commit Ms. Halbach's murder is contained on the hard drive of the Dassey computer, namely the material contained on the VLCD. The appellate court acknowledged that this evidence could be relevant to establishing the motive element in the Denny test and the new evidence directly connected to Bobby was raised. Specifically, the appellate court stated, the evidence, Lewinsky evidence, presented might supply a missing direct connection. In the event that the VCD evidence might become relevant to showing Dassey's motive, and might bear whether Dassey is or should have been a viable Denny suspect. Detective Veely's forensic examination of the Dass computer searched for specific words used the user had searched. Detective Veely selected the specific words and conducted the search for these words. There were 2,632 search results for the following words: blood, body, bondage, bullet, cement, DNA, fire, gas, gun, handcuff, journal, MySpace, news, RAV, throat, tires. The selected word established directly between the specific evidentiary items related to the Hallbox murder, and the search is performed on the Dass computer. The Veely CD contains states recovered pornography items relevant to material of the Hallbox murder. The Veely CD refined the 14,099 images of the 7 DVDs that the Child Defense Counsel received in discovery, and recovered 1,625 violent pornography images, which have been deleted. The recovered porn depicted violent images of torture and mutilation of young females. Brad Dassey, Barb's stepson and half-brother of Brian, Bobby, Blaine, and Brendan Dassey, avers that the conversation with Barb, in which she indicated that she had hired someone to remove evidence from the Dassey computer. The authorities interviewed Brad after he reported this information, and he was not called as a witness by either side to testify at Mr. Avery's or Brendan's trials. Affidavit of Brad Dassey. This is corroboration by a law enforcement report which states that on June 6, 2006, Special Agent Thomas Fassbender and investigator Mark Wiegert interviewed Brad Dassey, who provided the information about Dassey computer deletions. Thomas Fassbender DCI report attached to the incorporated hearings of Group Exhibit A1. The new forensic examination of the Dassey computer corroborates affidavit of Mr. Brad, but Mr. Hunt, in his computer examination, detected 8 periods in 2005, close to the date of the murder, for which the file is missing and presumably deleted from the Dassey computer. August 23, 2026, August 28th through September 11th, September 14th through the 15th, September 24th through the October 22nd, and October 23rd to the 24th, October 26th to November 2nd, November 4th through the 13th, November 15th to December 3rd. Supplement affidavit Gary Hunt. The question is, when were all those files deleted from the computer? And reviewing images, well, all the information has been sealed on behalf of Stephen Avery's request, so until he gets a new trial, we won't see all of that. In reviewing images contained on the VLC disc, Special Agent Thomas Fassbender made the following observations. Photographs of both Teresa Halbach and Stephen Avery were apparent on the apparent date of April 18, 2006. There were numerous images of nudity, both male and female, to include pornography. Pornography included both heterosexual, homosexual, and bestiality. There were images depicting bondage as well as possible torture and pain. There were also text images with the name Emily. There were images depicting potential young females, including an infant defecating. There were images of injuries to humans, including decapitated head, a badly injured bloody body, a bloody head injury, mutilated body, and discs received from Detective Veely, as well as the hard copy pages of instant message conversation maintained in Special Agent Thomas Fassbender's possession. The Thomas Fassbender DCI report had attached incorporated hearing Group Exhibit A2. There is sufficient evidence that it was only Bobby who had access to the Dassey computer during the day on weekdays between approximately 7 a.m. and 3:30 p.m. Barb's work schedule was from 6 a.m. to 4:30 p.m. every day, Monday through Thursday, every week. Brennan and Blaine would be picked up by the school bus at Avery Road between 7:08 and 7:13 a.m. and dropped off at the same place between 3:30 and 4 p.m. Therefore, Barb, Blaine, Brennan, and 3 other individuals living at the Dassey Abbott residence are excluded from even having access to the Dassey computer at the times the most violent searches occurred. Moreover, on 28 searches from the most violent porn images primarily occurred on weekdays when only Bobby was in the Dassey residence. It is undisputed that Mr. Avery never accessed the Dassey computer. He did not have password for the Dassey computer, nor did he possess a key to the Dassey residence, which was locked when no one was home. The only time Mr. Avery ever entered the Dassey residence was when one of the Dassey family members was home. Mr. Avery worked at the Avery salvage yard during the weekdays from 8 a.m. to 5 p.m. Moreover, Mr. Avery would have eliminated from all the 15 of the 128 11.7 searches the most violent porn images at issue, simply by having been arrested on November 9, 2005. Brennan would be eliminated from all but 26 of the 128 20% searches from the most violent porn images issue, simply by having been arrested on March 1st, 2006. Bobby testified on October 31st, 2005. He was the only person home between 6:30 a.m. and when he claims he left to go hunting at 2:45. Therefore, it is undisputed that Bobby was the only person home on October 31st when searches were made on his Dassey computer between 7 a.m., 9:33 a.m., 10 a.m., 1:08 p.m., 1:51 p.m. prior to Ms. Halbach's arrival at the Avery salvage yard. The timing of these internet searches, October 31st, directly contradicts Bobby's trial testimony that on that day he was asleep from 6:30 a.m. to 2:30 p.m. On November 17, 2017, in an interview with Bobby by state investigators, Bobby claimed that the Dassey computer was located on a desk in the living room at the time. When Bobby was asked if his Dassey computer was ever located in his bedroom, he stated it was not. Well, we have a walkthrough video when they released the property, and guess where the computer is sitting? Right in his bedroom. And they also claim that they didn't have internet at the time, but if you listen to the phone calls, you can have Stephen Avery asking Brian Dassey to go on the internet at Barb's house to look up to see if the van was placed on Auto Trader on the website. So many lies by so many people. It's sickening. Bobby's statements directly contradicted the crime scene from footage taken by Sergeant Tyson on November 12th, like I was just saying, which shows the Dassey computer was located in Bobby's bedroom. Bobby's statements are further contradicted by his brother, Blaine, who stated in the affidavit current post-conviction counsel on June 25, 2018, that the Dassey computer was located in Bobby's room and Bobby was the primary user of it. Proof of motive, opportunity, intent, preparation, plain knowledge, identified absence, and mistaken accident is admissible. The depicted acts in the violent pornography Bobby was viewing is sufficiently similar to the violent murder of Ms. Halbach. The evidence of Bobby's searches for violent pornography images is not so remote in the time of the inadmissible, but rather so close to the time of Ms. Halbach's murder that searches are direct evidence of Bobby's motive to kill Ms. Halbach. The 1,625 previously deleted but recovered images of violent pornography could have established motive for child defense counsel Denny Motion. The court, Mrs. Dressler McCaughey, held that the acts admitted pursuant to 904-02-04 were the defendant's possession of pornography, videotapes, and pictures. Those images depicting intentional violence and admitted the evidence of the defendant's motive intent to plan to murder the victim. Defendant and Dressler argued that the videotapes and pictures were irrelevant and constituted inadmissibility prospectively evidence. The Seventh Circuit disagreed, stating the fact that the defendant maintains a collection of videos and pictures depicting intentional violence is probative to the state's claim that the possession of subject or person obsessed with violence is more likely to commit murder. Therefore, the videos and photographs are relevant. The Dressler court held that although the evidence and general character of the defendant and the ability to provide acted conformity therewith, the above expectation from was deemed to apply. Dressler is pursuing the authority of the same result should occur here. Miss Halbach was killed in a violent manner, maintaining that the violent porn images prohibited to establish that Bobby had an obsession with the violence and therefore more likely to commit a murder. The violent porn images are relevant to Bobby's motive and would have resulted in trial defense counsel being able to establish his motive for Miss Halbach's murder to meet the Denny standard. As Mr. Avery's sexual homicide expert, Ann Burgess, excuse me, opines in an affidavit submitted previously in the court, there is well-established causal connection between pornography and consumption of violent behaviors. In Mr. Avery's motion considered court prior decision, former FBI agent and police procedure expert Greg McCary submitted an affidavit wherein he described his opinion in searches for violent, underage, and child pornography, combined with the images and searches of dead bodies, reflects the comorbidly sexually paralysis. In his opinion, Mr. Carnegie, the Bobby Dassey, was becoming obsessively deviant in his viewing of violent pornography. In the weeks before Ms. Halbach's murder, Bobby's opportunity to commit the murder of Teresa Halbach, the second prong of the Denny test, opportunity prong, asked, could the alleged third-party perpetrator have committed the crime directly or indirectly? In other words, does the evidence create practically a possibility that the third party committed the crime? As a legal concept, opportunity appears in Wisconsin statutes in the context and other acts, evidence, State versus Wilson. Other crimes, wrongs, or acts, evidence, other crimes, wrongs, or acts, and it is admissible to prove the character of a person in order to show that the person acted conformably therewith. The subsection does not exclude evidence with the offer of the purposes of proof and motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. The case law, as well as 9404, permits the introduction of other acts, evidence with the persons, whether party or third-party opportunity, engaged in certain contact opportunity in broad term. Proof of opportunity may be relevant to place of the person, science of offense, time and proximity, other one had requested skills, capacity, and ability to carry out an act, and the comments and proponent, however, to show the relevance of opportunity evidence. According to the trial court, Mr. Avery's trial defense counsel was already established that Bobby had an opportunity to commit the murder of Miss Halbach. The Sawinski evidence greatly strengthens the opportunity argument because Bobby is in possession of Miss Halbach's vehicle where her murder likely occurred. Bobby's access to items of evidence to frame Mr. Avery. Additionally, the defense theory was that Mr. Avery was framed by evidence being planted in Miss Halbach's car, in Mr. Avery's trailer, and burn barrel. Sawinski's evidence that Bobby was possession of Miss Halbach's vehicle provides the opportunity access to items that were used in the frame-up. The specific items that were planted and used in the frame-up Mr. Avery's blood in Miss Halbach's vehicle, Miss Halbach's RAV4 key, in Mr. Avery's bedroom, and Miss Halbach's electronic devices, in Mr. Avery's burn barrel. Bobby had access to Mr. Avery's blood. Mr. Avery told law enforcement in a recorded interview that his finger, which had been cut open prior to October 31st, 2005, re-bled on November 3rd, 2005, and dripped blood in his bathroom sink and his bathroom floor. In Mr. Avery's trial, Rolly Johnson, the owner of Mr. Avery's trailer, testified and observed that the cut on Mr. Avery's finger was present prior to October 3rd, 2005. Mr. Avery constantly expressed his belief with his attorneys and the media that his blood found in Mr. Halbach's vehicle was planted and that it came from the bathroom sink. Mr. Avery claimed that it bled into the bathroom sink and on the floor was corroborated by the fact that law enforcement found some of his blood on the bathroom sink and on his bedroom floor. They also found blood in his truck. They also found blood in his car. Mr. Avery provided affidavit on June 29, 2018. He stated the following in his affidavit regarding the events of the evening of November 3rd, 2005. I stopped at my sister Barb Dassey's Yanda's property and broke open a cut on the outside of my middle finger on my right hand as I was attempting to unhitch her trailer for her. I went to Barb's door to see if any of her sons wanted to go with me to Menards. Bobby and Blaine were home. I asked Bobby and Blaine if they wanted to go with me and my brother, Chuck, to Menards. I told both of them that the law enforcement officer had just left the property after asking me questions about Miss Halbach's visit to photographer Barb's van October 31st, 2005. I noticed that Bobby was immediately nervous after I mentioned the visit by the officer. He said that he could not go with me to Menards and that he had things to do. There is no doubt in my mind that Bobby saw that my finger was bleeding. My memory is that Blaine said that he wanted to go Menards and he went with Chuck and me. Prior to leaving for Menards, I returned to my trailer to put tape on my bleeding finger. A large amount of blood dripped onto the rim and sink and the floor of the bathroom. I did not wash away or wipe up because Chuck was waiting for me to go to Menards and Manitowoc with him. While we were leaving every property, driving a flatbed to Menards and Manitowoc, I saw taillights in the front of my trailer. The taillights were further apart and higher off the ground with sand taillights. I told my brother, who was driving, about the taillights. We turned around and drove back to my trailer, but the vehicle was gone. On November 4th, I woke up at 6 a.m. and went to the bathroom to take a shower. I saw that most of the blood on my sink, which I had not cleaned up previous night, was gone. It seemed to me that the blood had been cleaned up after reviewing more case documents and thinking about it happened on November 3rd, 2005. I do not believe that the law enforcement broke into my trailer and took blood from the sink planted in Miss Halbach's vehicle. According to Mr. Avery, he left his door unlocked when he went to Menards. However, the Dassey also had a key to his residence. Mr. Avery told law enforcement and the Child Defense Council that he was leaving his property around 7 p.m. on November 3rd and existing on Highway 147. He observed tail lights, the vehicle close to his trailer. Mr. Avery also told Child Defense Council that he noticed that the blood had been removed in the sink when he entered the bathroom early in the morning on November 4th, 2005. Also, when Stephen Avery was talking to the investigators on November 9th, he also tells them about these lights and says it could have been Bobby, because Bobby usually goes that way when he leaves the property. And when they blocked off the road after they got the property back, they were using Cuss Road to enter and exit the property. Even Dolores was using that route. Third and final prong of any test asks whether their evidence alleged the third party perpetrator actually committed the crime, directly or indirectly. The Sawinski evidence demonstrates that Bobby could have committed the murder because he is in possession of Ms. Halbach's vehicle, where the murder likely occurred and evidence of Ms. Halbach's blood in the vehicle. The vehicle is the key piece of evidence in the crime. It's the key, the biggest, in my concern, my opinion, but what I think means nothing. New evidence of Ms. Halbach's vehicle was returned to the Avery salvage yard. A different location corroborated from the fact that the witness saw a vehicle similar to Halbach's leave the property on October 31st. In Mr. Avery's trial, Mr. LeQuinn, a propane driver, testified that he saw a green mid-size SUV leaving the Avery salvage yard. Green. Anyways, Highway 147 between 3:30 and 4 p.m. October 1st. He informed law enforcement about this, and when he was stopped at the roadblock a few days later, he had heard about the news of Mr. Halbach being missing. Further, corroborating Bobby's brother Blaine's account, on June 25th, 2008, Bobby's brother Blaine provided Mr. Avery's counsel, the Post-Conviction Counsel, an affidavit attesting on October 31st, 2005, when the school bus driver brought Brendan and me home as we traveled west on Highway 147, I saw Bobby on State Highway 147 in a bluish or greenish vehicle heading towards Mishicot. Bobby was not driving his black Blazer. Bobby was not home the rest of the evening while I was home. Affidavit of Blaine Dassey. Bobby's trial testimony contradicts Blaine's affidavit because Bobby testified he was at home at 5 p.m. Bobby was with Michael Osmondson. What a surprise. When Miss Halbach's vehicle was discovered on November 5th, 2005, current post-conviction counsel investigator met with and interviewed Osmondson about whether he was an individual with Bobby pushing a RAV4 on the Avery salvage yard. The interview was conducted because Osmondson fit the height, weight, and beard description provided by Ms. Sawinski of the individual helping Bobby push the car. When Osmondson was asked if he was the individual who helped Bobby push the vehicle on the Avery property on November 5th, 2005, Osmondson responded that he could not remember if he was that individual. Affidavit by Stephen Kirby attached to the incorporated here in Exhibit B. I gotta read this again. Bobby was with Mike Osmondson when the Halbach's vehicle was discovered on November 5th, 2005. The current post-conviction counsel investigator met with and interviewed Osmondson about whether he was the individual with Bobby pushing a RAV4 on the Avery salvage yard. The interview was conducted because Osmondson fit the height, weight, and beard description provided by Mr. Sawinski of the individual helping Bobby push the car. When Osmondson was asked if he was the individual who helped Bobby push the vehicle on Avery property on November 5th, 2005, Osmondson responded that he could not remember if he was that individual. Well, we know that law enforcement learns that one of the Osmond boys was on the property between prior to the 31st and the 12th of November. But according to the Calumet County's report, when they talked to Mr. Mike O, he claims he was never on the property between the 31st and the 12th. And the only day he was there was the day he couldn't have been, because Stephen Avery was arrested on the 9th. And in trial, Mr. Kratz places Mr. Mike Osmondson on the property. So the fact that he says he can't remember if he was the individual who helped Bobby push a vehicle on the Avery property, if those were his exact words, wow. Further, the evidence of Bobby's insanity. Bobby was reported as the law enforcement alleged statement Mr. Avery said to Bobby and Osmondson about whether they wanted to help him get rid of a body. This was a major issue at trial. Trial defense counsel moved the mistrial, pointing out that he had been appraised by Bobby's new claim. During Bobby's direct examination, Prosecutor Kratz asked Bobby, "Now, Bobby, on the 3rd of November, there would be Thursday, I believe. Do you recall having a conversation with your uncle Stephen regarding a body?" The body responded, "Yes." On cross-examination, Bobby testified that Mr. Avery stated the remark about getting rid of a body in jest on November 3rd, 2005, when he and Osmondson were in his garage. However, Osmondson told law enforcement that Mr. Avery made such a statement to them on like I was just saying, on Thursday, November 10th, 2005. Only time Osmondson was on the Dassey residence between October 31st and November 11th. Sorry, I was wrong, because they talked to him on the 12th, when Bobby was inside the Dassey garage. Mr. Avery came over. This claim was equivocally false, since Mr. Avery was arrested on November 9, 2005. Remarkably, Osmondson stated to law enforcement that he had learned about the missing girl on Tuesday, November 1st, 2005, when Miss Halbach had not yet been reported missing. And if you listen to Bobby Dassey's 2017 interview, he misses up and states this exact thing, that they knew about her missing before it was even reported on the news. I just find it very funny that he will talk to investigators, but won't talk to her investigators. He'll talk to law enforcement, but won't talk to Kathleen's investigators. If you got nothing to hide, you should have no reason to hide anything. Talk to them. But anyways, I'll continue. There's still 120 more pages to go through. Remarkably, Osmond stated that law enforcement stated and learned about the missing girl on Tuesday, November 1st, 2005, and Miss Halbach had not yet been reported missing. Further, the record reveals that Osmondson and Bobby were either specifically calling each other repeatedly or with each other at relevant times after Mr. Halbach's murder. Bobby's phone records reflect on October 31st, 2005. There were 7 calls between Bobby and Osmond occurring between the following times in the morning and evening: 6:12 a.m., 6:36, 3:56, 3:57, 4:53, 5:10, 6:01. Bobby's phone records reveal that Bobby called Osmond a total of 66 times from October 24th, November 5th, November 9th, 2005. The Sawinski evidence is newly discovered directly links Bobby to Miss Halbach's murder because the previously stated Miss Halbach's RAV4 is the key piece of evidence in the murder. Here's a little side note on Mike Osmondson. Mike Osmondson was dating Marie Avery. And if you read Marie Avery's interview with Wendy Baldwin, she specifically states that Mike hates Stephen Avery. Doesn't go into detail why. I just thought that jumped out at me. I'd like to actually get these audio interviews, but it's kind of impossible to get things so far. But lately they've been releasing things, so maybe I should try some more FOIAs. The Sawinski evidence provides that the first time missing direct connection between Bobby and third-party suspect Miss Halbach's murder, and therefore not cumulative. Reasonable doubt in Mr. Avery's guilt. It is a defendant dissatisfies all 4 criteria of the newly discovered evidence that the reviewing court that examines whether it is reasonably probable that, and had jury heard the newly discovered evidence, would have had reasonable doubt to the defendant's guilt. This presents a question of law. Responsible probability of different outcome exists if there is a reasonable probability of the jury, looking at both the old evidence and new evidence, would have reasonable doubt in the defendant's guilt. Overwhelming evidence against the defendant may not serve as a basis evidence, including the third-party opportunity, direct connection to the crime, by elevating the strength of the only party's evidence. Not logical conclusion can be reached regarding the strength and contrary evidence offered by the other side, or whether it is cast out. If Bobby is established in a vehicle viable third party identity suspect, the forensic evidence in the case is completely undermined. Newly discovered evidence that Bobby was in possession of Ms. Halbach's vehicle means that the opportunity to access planned evidence of vehicle from the vehicle because Bobby has been directly linked to the murder of Ms. Halbach, and there's a reasonable inference that they planted the bones in Mr. Avery's burn pit. The new evidence creates reasonable probability that if the jury heard the new evidence, it would have reasonable doubt to the defendant's guilt. Therefore, Mr. Avery should grant a new trial. Brady violations are Sawinski's evidence. The Sawinski evidence not only newly discovered evidence, but also meets the criteria of Brady violation. After Sawinski contacted Mr. Avery's current post-conviction counsel and provided newly discovered evidence, Mr. Avery's current post-conviction counsel, through his investigator, submitted the second public records request pursuant to the Freedom of Information Act for audio recordings, incoming and outgoing phone calls, and or radio dispatches from November 3rd, 2005 and November 9th related to the Halbach case. See affidavit James Kirby, Tax Incorporated. Exhibit C. The FOIA produced audio recordings did not contain Sawinski's call on November 6th at 10:28 p.m., nor do they contain dates and times as the call is produced. In May of 2022, Mr. Avery's current post-conviction counsel received previously suppressed Sawinski call to the Manitowoc Sheriff's Office would contain partially record. Bam! This is it. This is the one thing she was needed. Previously suppressed Sawinski call in the Manitowoc Sheriff's Office would contain a partial recording of suppressed call to the Manitowoc Sheriff's Office on November 6, 2005. For the first time, current post-conviction counsel received the exact dates and times of the Manitowoc County Sheriff's Department Office incoming calls. Attached and incorporated the Exhibit D is an track timestamp required from the disclosure provided in May of 2022. As part of the further investigation, Mr. Avery's investigator interviewed Mr. Sawinski's ex-girlfriend, who had been dating him at the time of November 5th, 2005 incident. Mr. Lewinsky's girlfriend corroborated Mr. Lewinsky's account of what he had witnessed and that he had relied on new law enforcement further. Ms. Novak recognized and identified Mr. Lewinsky's voice on the recording played to her by the investigator of a phone call made to the Manitowoc Sheriff's Office on November 6, 2005 at 10:28 p.m. The affidavit of Ms. Devin Novak is attached to the incorporated Exhibit E. Mr. Avery's investigator also interviewed Mr. Lewinsky again and played some audio recordings of a phone call that was made in Mechanical Sheriff's Office on November 6, 2005 at 10:28. Mr. Lewinsky identified his voice on the audio recording at the phone call on November 6, 2005. The recorded Mr. Lewinsky call was never disclosed to the state to Mr. Avery's trial defense counsel prior to during the trial. Pre-trial, trial defense and counsel made two specific questions. Well, it was an ineffective assistance of counsel because they didn't do anything with the audio that they received. None of it. I mean, them finding bones miles away. I could go on. There's so much shit in that audio that they missed. Just the audio from November 7th. And officer statements. Like, but I'll get back to reading this brief. I'm going to be here for hours. Brady prosecuted duty to learn of favorable evidence known as other government actors, including the police. Brady's suppression occurs when the government fails to turn over evidence that is known only to police investigators and not to the prosecutor. There can be due process violation, inspectors of good faith, bad faith, or the prosecution. Prosecutor's duty to disclose evidence favorable to the accused includes the duty to disclose impeachment evidence as well as the explosive evidence. To establish a Brady violation, the defendant must demonstrate that the prosecution suppressed evidence, the evidence was favorable to the defense, and the evidence of material and issue trial. The state never disclosed Lewinsky evidence or the Lewinsky call to Mr. Avery's current, post, or past counsel. The defense never received a law enforcement report of the Lewinsky's evidence provided Manitowoc Sheriff's Office number 2005, Exhibit C. The Lewinsky evidence is corroborated by partially recorded his attempt to report the evidence to the Manitowoc Sheriff's Office prior to the call being transferred. There is no recording of law enforcement report that remained in Mr. Lewinsky's call to Mr. Avery, current post-conviction counsel, through reasonable diligence, has been able to locate through his public record request. A rule declaring the prosecutor may hide, defendant must seek is not tenable in a system constitutionally bound to accord defendants due process. Further, Wisconsin Supreme Court and statute. The court has never analyzed the Brady claim through the lens of reasonable diligence and declined to adopt the requirement now, due to the lack of grounding in the Brady legislative Supreme Court procedure. There is no express support of the United States Supreme Court, Brady with jurisdiction and limitation, other favorable material evidence, and the exclusive possession of control, blah, 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 blah. There is no duty to defense to seek the information that has been disclosed. However, Mr. Avery's current post-conviction counsel has made diligent efforts to obtain any and all information regarding the Lewinsky evidence, including requesting all incoming calls to the Manitowoc Sheriff's Office from the relevant time period. The following timely and strict diligence demonstrated Mr. Avery's current post-conviction counsel investigating and recording evidence of Mr. Lewinsky provided in Manitowoc Sheriff's Office November 6, 2005. Mr. Lewinsky emailed Stephen Avery Lawyers gmail.com summary of what had observed on November 2005. Subject line in the email was needed to talk. Investigator Thomas Lewinsky credibility. Mr. Avery's current post-conviction counsel conducted the investigation of Mr. Lewinsky, which included gathering information which following the date of the birth, relatives, employment history, telephone numbers, email addresses, yada yada yada. Mr. Avery's current post-conviction counsel confirmed that Mr. Lewinsky had worked for Manitowoc Herald during the relevant time period. Mr. Avery's current post-conviction counsel contacted Mr. Avery's trial defense counsel, Mr. Buning, who confirmed that Mr. Avery's trial counsel did not have received any emails from Lewinsky. Mr. Avery's current post-conviction counsel reviewed all discovery for the requests made by the prior counsel and current post-conviction counsel to the Manitowoc Sheriff's Office and information related to Lewinsky. Now, just think, if Jerry Buting wouldn't have asked what Dave Remaker used to prepare for his testimony during the pretrial of Stephen Avery's, what was that, the December hearing, they would have never known we had any of this audio because Remaker slipped up. And Jerry Bruning, he should ask for all audio, not just audio he used to prepare, because obviously he had no idea that any audio existed at the time whatsoever. But we could sit here and scrutinize everything they did, but that's after the fact. We're talking about real time. And the fact that the prosecution hid so much stuff, it's blatantly seen. I mean, you just one violation is enough to get him a new trial, or at least an evidentiary hearing. One violation. He's got multiple, several. April 7, 2021, Mr. Avery, current post-conviction counsel, sent and delivered a letter to Mr. Swinsky through a local investigator in November, Colorado, where Mr. Avery's current post-conviction counsel determined Mr. Swinsky resided, requesting Mr. Swinsky contact Mr. Avery's current post-conviction counsel office immediately. April 8th, Mr. Avery, current post-conviction counsel, and her clerks had telephone contact with Mr. Swinsky and arranged a time to speak to him further. April 9th, 2021, Mr. Avery, current post-conviction counsel, and clerks conducted a phone interview with Mr. Swinsky. Mr. Avery's current post-conviction counsel prepared an affidavit. Mr. Swinsky indicated that he was going to visit family in Manitowoc on April 10th. Post-conviction counsel investigator Stephen Kirby met Mr. Swinsky and in person in Manitowoc for an interview, reviewed his affidavit with him. Affidavit described the evidence Mr. Swinsky reported to the Manitowoc Sheriff's Office and observed the Avery property while delivering a newspaper on November 5th, 2005, with actions towards. His affidavit includes the map indicating where reserved two vehicles, pushing a RAV4. After reviewing the affidavit and making any necessary changes, Mr. Swinsky executed the affidavit before Wisconsin Notary. Sorry. April 12th, Mr. Avery's current post-conviction counsel appealed a motion to stay appeal and remand the case, supplemental post-conviction motion, which new witnesses affidavit establishing a Brady violation. August 28th, counsel listened to audio recordings in the possession from discovery as well as own investigation, determined that there is no recording matching the description that Mr. Swinsky provided to the Manitowoc Sheriff's Office. March 15, 2022, Mr. Avery, current post-conviction counsel, through the investigators, submitted the following three new public records requests to the Manitowoc County Sheriff's Office. First, request copies of all 911 recordings, the possession and incoming telephone calls. John Joint Dispatch Center between dates of November 3rd and November 9th. The second request, through copies of incoming outgoing calls, logs recorded Manitowoc County Sheriff's Joint Dispatch calls between the dates of November 3rd and November 9th, and related to the Teresa Hallbach investigation. Information should include date, time, and telephone numbers involved in the calls. Third request sought copies of audio recordings incoming and outgoing calls, radio dispatch between dates of November 3rd, 2005, 12:01 p.m. through November 9th, 2005, 11:59 p.m. And related to the, it should be from November 3rd, 12:01 a.m. to November 9th, 11:59 p.m. But either way, they got it. In response to Mr. Avery's current post-conviction counsel on March 15, 2022, public records request to the investigator the first time, recordings were provided to Mr. Avery's current post-conviction counsel, who thoroughly reviewed and listened to all the recordings that were recorded which took place on November 6, 2005, 10:28, first time the time and the date of the calls are revealed in the track files. Current post-conviction counsel investigator Stephen Kirby met with Ms. Swinsky, his former girlfriend, Ms. Novak, on August 6, 2022, and played for her the audio recordings from November 6, 2005, 10:28. Ms. Novak identified the voice on the call as Ms. Swinsky, and Ms. Novak provided Mr. Avery's current post-conviction counsel with affidavit regarding voice identification and recollection of being with Ms. Swinsky when he placed the November 6 call to the Manitowoc Sheriff's Office. August 6, 2022, a current post-conviction counsel investigator Stephen Kirby met with Ms. Swinsky and played him the audio recording of November 6, 2005 at 10:28 p.m. Ms. Swinsky identified this as the following the call Mr. Lewinsky provided. Mr. Avery first government post-conviction counsel with affidavit regarding the voice identification. As stated above, a very thorough investigation of Lewinsky individually and accuracy of information provided the Lewinsky evidence. Mr. Avery's current post-conviction counsel determined that Lewinsky evidence necessitated failing the third motion. In order the defendant prevail on the third component of the Brady analysis, suppressive evidence must be material. Their evidence material only if there is a reasonable probability that the evidence disclosed in the defense result of the proceeding would have been different. Well, 100% would have been different. That's a fact. Mr. Avery's conviction of first-degree intentional homicide was a large part of the basic child defense counsel unsuccessful efforts to name a third party. Danny suspect that met all the Denny requirements. Lewinsky evidence meets the Denny requirements. It makes Bobby a third party Denny suspect in the murder of Miss Halbach also. Lewinsky evidence meets the Denny requirements establishing Bobby as having framed Mr. Avery for the murder. Bobby possession of Miss Halbach's vehicle gave him access to the opportunity to plant Mr. Avery's blood and the DNA and remove evidence from the vehicle that implanted in Mr. Avery's bedroom. Miss Halbach's key, burn barrel, Miss Halbach's electronics. Lewinsky knew immaterial evidence was suppressed with the Manitowoc Sheriff's Office failed to disclose November 6, 2005, 10 p.m. audio recording pursuant to the defense discovery request. The disclosure of the audio recording would have led to the identification of Mr. Lewinsky and evidence provided which directly connects Bobby to the murder and framing of Mr. Avery. Lewinsky evidence is both material and favorable in Mr. Avery case. Now, the fact that the law enforcement had all this information just proves that they did this on purpose, just like they did in 1985. Like I said, the only difference between 85 and 2005 is Penny didn't die. Lewinsky evidence is material because it makes Bobby a third-party Denny suspect in murder as well as the source of planted evidence used to convict Mr. Avery. Lewinsky evidence also impeaches Bobby's testimony and refutes the state's theory that Miss Halbach Ford never left the Avery property and that Mr. Avery was the last person to see Miss Halbach alive. Further, material favorable evidence not only includes exculpatory evidence but also evidence that impeaching of the prosecution witness. Evidence trending to discern the lack of credibility of the prosecution witness is material, especially where the prosecutor's case depends on the credibility of that witness. Bobby was the state's primary witness against Mr. Avery at the trial. During his opening statement, prosecutor Ken Kratz explicitly informed the jury of the significance of Bobby's putative observation the day of Miss Halbach's disappearance. You are going to hear that Bobby Dassey was the last person, the last citizen that will have seen Teresa Halbach alive. Bobby testified that he observed Miss Halbach's vehicle pull up in his driveway at 2:30 p.m. on October 31st. Bobby then observed Miss Halbach exit her vehicle and started walking towards his mom's room van right in front of his trailer. Bobby testified that then he observed Miss Halbach walking towards the door of Mr. Avery's trailer. He testified that he never saw her again after that, and then he testified that he took a 3 or 4 minute shower, and then left to go to his trailer to go hunting. Bobby walked to his Chevy Blazer, which was parked between the trailer and the garage, and testified that he was walking to his vehicle. He observed Miss Halbach's vehicle still parked in the driveway. He further testified that he did not see Miss Halbach or any signs of her. Contrary to Bobby's trial testimony, Miss Halbach was still on the Avery property when Bobby left to go bow hunting. Brian, Bobby's brother, told law enforcement that Bobby saw Miss Halbach leave the property on October 31st, 2005. On November 6, 2005, special agents with the Wisconsin Department of Justice criminal investigators interviewed Brian. With the investigators asked Brian about the events on October 31st. He told the investigators that he was not home during the day other than waking up and going to work. He told the investigators the following. Brian said he heard from his mom, Ms. Stevie, that Halbach was only at their residence about 5 minutes. He heard that just took a photo of the van and left. Brian said that the investigators should also talk to his brother Bobby because he saw her leave their property. The state was in possession of that report on the time of Mr. Avery's trial. Despite knowing the information, the state presented false testimony from Bobby. Remember, Kratz prepares all of his witnesses. They said that he says that when they bring up the whole Mike Osmondson Bobby Dassey confrontation that happened in the garage, he completely just, yeah. Well, you guys all know, I'm sure. I hope you know. I know there's new people coming in this case every day, and there's so much to learn. October 16, 2017, Brian provided current post-conviction counsel with the affidavit confirming that Bobby told him he saw Miss Halbach leave the property on October 31st, 2005. In his affidavit, Brian states as follows. On or about November 4th, 2005, I returned to my mother's trailer to retrieve some clothes that I had a conversation with my brother Bobby about Teresa Halbach. I distinctly remember Bobby telling me Stephen could not have killed her because I saw her leave on the property on October 31st, 2005. Then we have the 2017 phone call between Stephen and Barb and Scott in the background, and they both confirmed that Bobby said that he's seen her leave the property. The appellate court highlighted the importance of Lewinsky evidence was following in its July 28, 2021 opinion to admit evidence at trial that Dassey could have killed Halbach. Avery would have provided some evidence of the pretrial Denny hearing directly connecting Dassey to the crime. Evidence another party committed the crime may be admissible pursuant to Denny if the defendant read this like 4 times now. Will the appellate court determine that Mr. Avery did not have sufficient evidence to meet the Denny requirements to admit the evidence at the trial, and Bobby could have killed Miss Halbach? It is also advised that Lewinsky evidence could be that missing direct connection. Because Lewinsky's evidence suppressed and trial defense counsel was not able to establish Bobby as a third-party Denny suspect and impeach Bobby's trial testimony as the state's primary witness, as a result, Mr. Avery did not receive a fair trial. Mr. Avery had a constitutionally guaranteed right to present complete defense of the charges against him. Prior to discovery of Lewinsky's evidence, the appellate court stated that impeaching Bobby would not have undermined the cumulative effect of the significant forensic and other evidence implicating Avery in the crime committed on his property. However, discovery of the Lewinsky evidence transforms the evidence from implicating Mr. Avery to implicating Bobby in the murder and planting of evidence to frame Mr. Avery. Even if the court determines that the evidence implicating Mr. Avery remains significant and unconstitutional to refuse to allow the defendant to present the defense simply because the evidence against him is overwhelming. Because of the existence of new Lewinsky evidence, Mr. Avery must be allowed to present a defense based upon it. The reasonable probability that different results exist as suppressed information undermines confidence in the verdict. The suppressed Lewinsky call undermines confidence in Mr. Avery's verdict. Its disclosure would have led to the discovery of Lewinsky's evidence, which established Bobby as a third-party Denny suspect, both the murder and planting the evidence to frame Mr. Avery. It also impeaches Bobby's trial testimony, which was fabricated in order to exclude himself and frame Mr. Avery for the murder of Miss Halbach. Mr. Avery is not procedurally barred from raising the Brady violation. A motion for relief, 97406, is part of original criminal action and may be made at any time. However, a defendant must meet the certain requirements. All grounds reliable available to the person under the section must be raised in his original supplemental amended motion. Any ground finally executed and not so raised knowingly, voluntarily, intelligently waives the proceeding and results in the conviction and sentence or any other proceeding the person is taken. Secure relief may not be basis for subsequent motion unless the court finds grounds for the relief asserted for sufficient reason was not asserted and inadequately raised in the original supplemental amended motion. The Wisconsin Supreme Court held the claim that it could raise a direct appeal in Wisconsin post-conviction motion barred from the raised subsequent. I'm not going to read all this. This is just all case law and why it should not be procedurally barred, and I think we got told to the meat of the brief. I mean, there's still 103 more pages to go through. June 2017, second post-conviction motion. Sawinski evidence related to Mr. Sawinski to the Manitowoc County Sheriff's Office was never provided to Mr. Avery's prior counsel by the state. The Sawinski evidence was discovered by Mr. Avery's current post-conviction counsel after being alerted to existence by Mr. Sawinski in December of 2020. Current post-conviction counsel had then thoroughly investigated and corroborated Mr. Sawinski and Sawinski's evidence. As paragraph 83 above illustrates, Mr. Avery's current post-conviction counsel was diligent in investigating and corroborating Mr. Sawinski and Sawinski's evidence. The Sawinski evidence provided to Manitowoc Sheriff's Office on November 6, 2005 was unknown to Mr. Avery and is undiscoverable at the time of Mr. Avery's 2017 post-conviction motion. In 2013 post-conviction motion, direct appeal in 2007 trial, it could not have been known the discovery of Mr. Avery's because Mr. Sawinski had not come forward to Mr. Avery's current post-conviction counsel until April 2021, and the state had suppressed audio recordings in November 6, 2005 phone call to the Manitowoc Sheriff's Office, reported his observations on November 5, 2005. Therefore, the Sawinski evidence was known at the time of Mr. Avery's conviction, was not discoverable by reasonable diligence, and was not under the control of the knowledge of Mr. Avery at any time prior to Mr. Sawinski's contacting Mr. Avery, current post-conviction counsel, in December of 2020. It is the discovery of Brady violation subsequent to filing the motion pursuant to consist of the sufficient reason for failing to raise the issue in the prior motion. Even if the court determines that the Brady violation of the Sawinski evidence qualifies as newly discovered evidence described above, Mr. Avery has sufficient reason for not having brought forth the newly discovered evidence. Avery did not know he could not have known the Sawinski evidence until Mr. Sawinski came forward in December of 2020. Therefore, the court should find that Mr. Avery is not procedurally barred from raising his newly discovered evidence claims of his new Brady claim regarding Sawinski evidence. Kevin Ramlow came forth to Mr. Avery's current post-conviction counsel with new information in July of 2017. Mr. Ramlow provided an affidavit, a supplemental affidavit to the current post-conviction counsel because Mr. Avery's second post-conviction motion filed on June 2017. The affidavits were filed and Mr. Avery's motion reconsidered the circuit court's October 2017 ruling denying the second post-conviction motion. In Mr. Ramlow's affidavits, Mr. Ramlow describes observing Ms. Hallbach's RAV4 parked at the turnaround on State Highway 147 at the East Twin River Bridge on November 3rd and November 4th, 2005. Mr. Ramlow describes the affidavit reporting his observation of Manitowoc Sheriff's deputy encountered on November 4th, 2005 at the Senex station on State Highway 147 in Manitowoc. No law enforcement report was ever generated by Manitowoc Sheriff's deputy, memorializing his conversation between Mr. Ramlow and his deputy. Mr. Ramlow's observation of Ms. Hallbach's RAV4 on November 3rd and 4th, 2005 is the material to trial defense counsel their theory the evidence was planted to frame Mr. Avery. If the RAV4 was spotted at the turnaround on Highway 147 on November 3rd and 4th, then it must have been moved to plant to the Avery property before it was discovered on November 5th, 2005, which was also explained why we have the edited flyover video, because they spotted her car. They had to. If it was parked at that turnaround and they flew over that area, they would have seen it. People seen it driving by. So the Hallbach vehicle turnaround off. Both witnesses support trial defense counsel theory that the RAV4 was planted. Prosecutor Kratz admitted in the closing that the RAV4 couldn't have been driven onto the property unless somebody knew that property. The only other evidence presented by the state, RAV4 never left the Avery property on October 31st, 2005, was Bobby's testimony that the RAV4 was still present when they left the Avery property at 2:45. Trial defense counsel had no evidence. Witnesses the RAV4 was planted and simply argued in closing that there was lots of ways to get in and out for someone to plant a vehicle. The Appellate Court, July 2021 opinion. The Appellate Court noted that Mr. Avery's motion for reconsideration, he raised the issue that the state withheld evidence that Hellbach vehicle had been seen on the street days of his disappearance. The Appellate Court declined ruling on this issue and advised the following. Neither were not the Circuit Court have squarely considered whether these claims are procedurally barred under Escalante and other Avery pledged sufficient material facts entitling him to bearing. Although our analysis overlaps the former inquiry, such consideration would have to come to separately filed Wisconsin 97406 and would express no opinion that other such claims would be barred, and such motion is filed. Clearly, current post-conviction counsel has not could not have included Mr. Ramlow's affidavits in June 2017, filing on behalf of Mr. Avery since Mr. Ramlow had not come forward until evidence established a better violation. There is no way that Mr. Ramlow could have been discovered from a prior defense counsel, current post-conviction counsel, based on new info. I just thought of something. If they never would have made Making a Murder 2, Ramlow might not have come forward. Ramlow would not have come forward unless he's seen the first one, because he claims he didn't come forward until after seeing Making a Murder 2. So, interesting. Mr. Avery has sufficient reasons for not raising the issue previously pursuant. An alternative, Mr. Avery is entitled to a new trial in the interest of justice pursuant to Wisconsin 805-15. One moment. Alternative, Mr. Avery is entitled to a new trial in the interest of justice as the court were included the new evidence warrants a new trial in the interest of justice. This court need not resolve whether the new evidence just satisfies the test for granting a new trial based upon new discovered evidence. Wisconsin 805-15 establishes that the standard for granting a new trial under circumstances such as these is whether the new trial would advance the interest of justice. A party may move to set aside a verdict for a new trial because of errors in trial, or because the verdict is contrary to the law and weight of evidence, or because of excessive, inadequate damages because of newly discovered evidence in the interest of justice. Courts may grant a new trial in the interest of justice whenever either the real controversy was not fully tried, or the probability that justice was for any reason miscarried. In the first circumstances, when the real controversy has not been fully tried, the court may grant a new trial without considering whether the outcome would probably be deferred on retrial. Now, my question is, what is Angela Sukowicz going to do? Is she going to do the right thing? Take a break here and see what you guys have to say. I don't rarely look at the chat very often when I do these, so. I'm fine. I stayed up all night waiting for this to hit the website. An evidentiary hearing is required. No shit, Sherlock. The circuit court must have had to hold a hearing when the defendant has made a legally sufficient post-conviction motion, and the discretion is granted to deny evidentiary hearing, even when the post-conviction motion is legally insufficient. The Wisconsin Supreme Court, State Allen, determined that the motion contains sufficient material facts in an evidentiary hearing if it includes the names of the witnesses, who, the reason the witness is important, who, how, the facts that can be provided, what, where, when, and entitled the defendant to a hearing. The Wisconsin Supreme Court in the State versus Allen determined that the motion contains sufficient material fact in evidentiary hearing if it includes the name of the witnesses, who, blah, 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 blah. Mr. Avery has sufficiently pled the name of the witnesses, Mr. Sawinski, and the reason Mr. Sawinski is important, who provides evidence material favorable to Mr. Avery by directly connecting Bobby to the Hallbach murder as a third-party suspect, connecting Bobby to planting evidence to frame Mr. Avery. All corroborating materials have been identified, attached, and incorporated in the motion. Affidavits, law enforcement, testified trial testimony. These corroborative materials demonstrate that the Bobby is a third party, Denny suspect, because he had motive, opportunity, and directly linked to Miss Hallbach's murder. Additionally, he is a Denny suspect who would directly link to plant the evidence of Mr. Avery having access to the key evidence in the crime because of the possession of the Hallbach's vehicle. Additionally, a new bright violation has been identified as described previously in the motion. Similarly, Mr. Avery has sufficiently pled the name of the witness, Mr. Ramlow, and the reason Mr. Ramlow is important, provided evidence material, and favorable to Mr. Avery, refutes the state's theory that impeaches Bobby and the Hallbach vehicle never left the Avery property. Also, Mr. Ramlow describes a new Brady violations, and a law enforcement report was never made of Ramlow's conservative in the Manitowoc Sheriff's Department on November 4th, 2005. After Ramlow spotted in RAV4 in the location. After reading this so far, I'm really disappointed on all the news avenues that reported on this yesterday, because they barely even scratched the damn surface. Whoever did the reports on I don't remember which newscast I seen, but they did a piss poor job. The Suminsky and Ramlow evidence would have been material favorable to the trial defense counsel because it would have undermined a confidence in the verdict. Because of the suppression of the evidence, Mr. Avery did not receive a fair trial. Mr. Avery had a constitutionally guaranteed right to present complete defense of the charges against him. If the court is declined to believe that Ms. Suminsky and Mr. or Ramlow knew evidence, the court must hold a hearing before making any credibility determinations, holding that when the credibility is the issue, it is best resolved by live testimony. Conclusion. Mr. Avery respectfully requests that the court grant him the following alternative remedies. 1. Order the state to file a response to the third motion for post-conviction relief and or grant an evidentiary hearing. 2. Grant this motion for prosecution post-conviction relief by ordering a new trial, grant the requested relief, and grant any and all relief this court deems appropriate. Dated this date, 16th of August, 2022. Okay, so that was 50 pages of the brief, so all the other ones are going to be the exhibits that are attached. So we have 98 more pages of documents to go through. Yeah, based on Angela Sikowitz's prior history with this case, when Zellner submitted her brief for scientific testing, over 1,000 some pages, she immediately denied it. But moving forward on another brief that Zellner filed, the last one before they went to the Court of Appeals, she dragged it out. And then COVID happened. But yeah, it's just a bunch of bullshit. And the fact that Angela Sukowitz was the judge that would have been handling the civil lawsuit brought on by the Hallbachs against Stephen Avery, and from what I hear, I don't know if it's factually to be true, because there's lots of things that people hearsay, and yeah, that she tried convincing them to continue with their lawsuit against Avery, even after the Hallbachs decided to terminate. Alright, this is Wisconsin Department of Justice, Division of Criminal Investigation, Access Investigation Report, dated 6/13/2006, reported date 5/13/2006, reporting law enforcement officer Thomas Fassbender. Exhibit. On Tuesday, June 6, 2006, at 2:04 p.m., Thomas Fassbender and Rescue Wiegert of Calumet County Sheriff's Department interviewed Brad Dassey. All this is, I don't want to read all this. This is all in CASO and all the files we've gone through. This is just proving what she cited up, what we've already read through. And this is kind of hard to read because it's not all there. Dear Lord, thou you Almighty God, you control the heavens, you control our lives, you also control all the evil in this world. I was very afraid to contact you, Hallmark family, due to the fact that I am indeed a Dassey through marriage. My real mom. Oh. Well, I'm sure Brad has his original letter. Right. Scott's Friday, April 21st, 2006. Mark Weird. Department seized their personal computer. Oh, this is about the Grand Chute Police Department in Veely and the CD. Exhibit B. Affidavit of Stephen Kirby. Now-comers affiant Stephen Kirby under oath hereby states as follows. We are affiant to legal authority and truthfully complain to testify, yada yada yada. You are affiant Chairman Edward. On February 16, 2022, your friend interviewed Michael Osmundson outside of his residence at 955 Main Street, Michigan. Jim Kirby was also present and witnessed the interview at Osmundson. So, Michael Osmundson will talk to investigators, but Bobby Dassey won't. Your client asked him if he ever helped Bobby Dassey push a car down a road leading to Salary Salvage Yard. He replied, I don't recall. We all are familiar with that phrase, everybody. I don't recall. Your client then asked him if by saying he didn't recall, if in fact he could have helped Dassey push a car down the road in November of 2005, but just forgot that he did. He replied, I don't remember. And at the conclusion of the interview, your client told him that your client wanted to be sure that he was not denying ever pushing the car with Dassey towards their property, but that he couldn't recall if he had or did not. For the third time, he replied, I don't recall. In regard to the phone calls on October 31st, 2005, to and from Bobby Dassey's phone number, he said he didn't recall making or receiving calls from Dassey that morning. When he was shown the printout of the message units, he said that was his number in 2005 and recognized the 920-973-1742 as Bobby Dassey's number. He stated that the early morning call could have been about hunting, but he didn't know for sure. When asked if he went hunting with Bobby that day, he said that he didn't. He took his brother trick-or-treating. When asked about the multiple calls to and from Bobby Dassey between 3:56 p.m. and 6:02 on December 31st, 2005, he said that he couldn't explain them other than that Bobby often doesn't answer his phone. Exhibit C. Affidavit Attorney James Kirby. Public records, Response Hawk Sheriff's Department regarding seeking non-911 recordings, the possession of incoming phone calls. It's funny that I was told that this information doesn't exist and it was destroyed. And then the sheriff retires. Lavina retires. And now we're getting access to everything. And now that Wiegert is retiring, depending on who takes up his place, who knows what else they're hiding. It'd be nice if they could get access to Just take a look at Manitowoc Sheriff's Department's safe in this Colburn lawsuit. Just take a look. You ain't gotta take nothing. Just look at it. Okay, nothing's supposed to leave the Sheriff's Department. We have received and reviewed requests for any non-recordings in possession and calls in Manitowoc County. This man, all she needs is her day in court. This is one and done. There's so much information that she hasn't even talked about, to my knowledge. But that'll all come when trial comes. On March 15, 2022, investigator Catherine McGovern of the Finance Office submitted 3 public records requested to the Manitowoc County Sheriff's Office of requested copies of 911 recordings, telephone calls, outgoing, incoming, and Joint Dispatch Center between dates of November 3rd and November 9th. Although the truthful organization, the information should include date, time, telephone numbers involved in calls, third-party requests, blah, blah, blah. April 18, 2022, Catherine McGovern from the Finance Office received an email from Amanda. Manitowoc County Sheriff's Office regarding these questions in the email. Amanda replied that she was updating Ms. McGovern regarding the request to accompany incoming, outgoing calls, logs, or responding to those records did not exist. In reference to the request of the copies of audio recordings, incoming and outgoing phone calls, attached incoming, an amount $360 for these records. She requested your Finance Office for payment so that she may begin working on copying these records. Your Finance Office subsequently paid invoice and requested it. Well, yeah, some of these FOIA documents are not cheap. On May 3rd, 2022, your Finance Office, just look how much they paid for those deposition transcripts. Everybody crowdfunding for that. Be nice to get the videos too. On May 3rd, 2022, your Finance Office received 35 CDs marked as containing audio recordings of the Manitowoc County Sheriff's Office. On May 3rd, 2022, your Finance delivered 35 CDs to the office of Kathleen T. Zunner. The recording of the phone calls from November 6, 2005, 2028 was contained within one of the 35 CDs produced from the Finance Record Circuit public record request. It was discovered in the Finance Office of Kathleen T. Zunner. Your Finance listened to these calls. Your Finance listened to the new 2 CDs produced to the Finance after your Finance first public record request to the Manitowoc Sheriff's Office on March of 2018. The recording of the November 6, 2000 phone call in which Nowinski's voice was identified was not an initial disc provided to the Finance following the Finance March 20, 2008 public record request. Blah, 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 blah. Exhibit D. Oh, it's all the phone calls. Exhibit E. Affidavit. Devon Novak. Thomas Nowinski presented as just her stating that she listened to the recording, and yes, and in fact, it is Thomas Nowinski's voice. And here is the printout of what took place during that Manitowoc Sheriff's Office. This is Carla. Can I help you? Mail. I don't know if it's good information. Bad information. Who do I talk to about this? This girl is missing from Hilbert. I can have you speak with the shift commander. Can you hold on a minute? Thank you. Sure. I'm going to transfer you to the shift commander. You'll be talking with Sergeant. Okay, we all know who all the I know who all the shift commanders were during that time, so. And it had to have been somebody that was at the station, because we know everybody was at the property. And we look at sign in, sign out sheets to see who was there and where, so. Scott, when I hung up a man on the phone who thinks he has some maybe leads he wants to speak with somebody on this phone, Sergeant. All right, end of call. But I'm sure I know all these people's voices by heart, so, which is sad. The majority of truthfully completed testimony contained upon factual statements here are untrue. Best knowledge, I desire a man's walk. This is just the affidavit that we've all read in prior filings. I've done this in the video before. This is the depiction of Avery Road and where they were approximately located when he drove past the individuals pushing the car onto the property. This is the email that he sent to Kirby. I've read all this in previous videos. I'm going to waste my time going through this. Scott hung up, man, his phone, thinks he has something in the case. Scott Sanglob. That's who it was. Didn't even have to listen to it. Dean Strang first lead sworn that he hereby files the council drum breed secret master phrase. This is their affidavit saying they infected assistants of counsel. Dean Strang, Jerry Budine. Affidavit of Jerome Budine. About the CD round, VLCD. I'm going to post a link to this in the description, so if you guys actually want to go through and read all this, because most of this is all pre-cited in her previous filings. Let's see. I made similar through perhaps not detailed requests about 1 month ago, and I believe Mark Wiegert spoke to Dean, and he is working on this already. The listing of Calumet Manitowoc County Sheriff's Department personnel involved in the investigation was includes officer, personnel squad, and 801 arrived. Copies of video recordings made of the RAV4 at its location were discovered at the Avery. Copies of video recordings made of the RAV4 at its location were discovered at the salvage yard. Copy of all video recordings made of the interior of Stephen Avery's trailer, garage, vehicle. I believe the reports reference Sergeant Tyson making such recordings. Copy of all video recordings of the burn barrels as well as burn pit before it was all. See, I knew all this shit fucking existed. They're just fucking hiding it and wouldn't release a fucking thing. But why would they want to release things that would point to the truth when they framed the man for the second time? About Brad's affidavit, about having the computer, then Brad's letter to the hall box. Oh, y'all got any questions? I think I'm pretty much done reading all this. It's just seems to be everything that we've already learned prior to, but I will go through it still. Kirby under oath. Kirby CD. Someone sees correct. He indeed saw what he saw. He saw it had to be November 1st a.m. hours, but you might move the turn signal after having possession RAV4. How do you know what he's incorrect of seeing? Were you there looking through his eyes? I mean, we're all entitled to our opinion, Mr. Forcrum, but please explain. Yeah, it sucks that Judge Sikowitz is the judge seeing over this. Yes, Kevin Ramlow went to school with them. He's from the area, went to school there. Super Day. I'm an employee of Gannett. This is his affidavit. Again, yes, see, this is emails that he sent. Yeah, Kevin Ramelow went to school with Barb. That's correct. It's a small town. There's only a few schools, high schools, and grade schools in that area, especially back then. But now we wait. Question is, how long is Judge Suck going to take to rule on this? Hour and 45 minutes later, but I don't know. I haven't learned anything new, except for it's quite interesting that Mike Osmundson talked to Zellner's investigators, but somebody won't. It's not looking good for you, buddy. Yes, we all have our opinions. Some think she's still alive. But until next time, I'm sure there'll be an update in the Colborn case coming soon. Y'all have a good day. Stay blessed.